Judgment in the matter of Maughan against Maughan.
Sir Declan Maughan will explain the Court's judgment.
This appeal concerns the principles applied by the Northern Ireland courts when considering what, if any, discount to allow a defendant who pleads guilty to serious crimes. The appellant and his brother carried out a series of violent burglaries. They were detected when he and his brothers left the scene of a burglary in a householder's car. The police were informed and successfully detained the occupants of the car, which contained the proceeds of the burglary. The police then obtained CCTV evidence in respect of other such burglaries in which the appellant had been involved. He was arrested and brought to a police station, but refused to participate in an interview. He was charged and brought before a magistrate's court. He made a number of appearances there before his committal to the Crown Court many months later. He pleaded guilty when arraigned in the Crown Court. The Crown Court judge reduced the discount for the plea because he had not admitted his guilt when asked for interview and because he had been caught red-handed in respect of the offending. Article 33 of the Criminal Justice Northern Ireland Order 1996 provides that a court must take into account the stage of the proceedings at which the accused indicated his intention to plead guilty when considering sentence. The appellant submitted that the proceedings commenced when the appellant was charged and the interview was not a stage in the proceedings. He also submitted that the reduction of discount when an accused was caught red-handed no longer applied in England and Wales or Scotland and should not be applied in Northern Ireland. It is accepted that the proceedings for the purpose of the 1996 order do not include the investigative stage before charge. Article 33 does not, however, inhibit the development and application of sentencing policy by the Court of Appeal in Northern Ireland. There are different statutory backgrounds in each jurisdiction in the United Kingdom. The judgment explains how that background informs the manner in which sentencing policy develops. It is accordingly unsurprising that there may be some variation in the application of sentencing policy in each jurisdiction. There is an underlying principle in each jurisdiction that there is a public interest in securing a guilty plea at an early stage from those who have committed criminal offences. There are three obvious advantages to such a principle. First, an early plea will vindicate victims and relieve witnesses who might otherwise have to give evidence. Secondly, an early plea will reduce the use of resources expended by the police and prosecution services in preparing for trial. Thirdly, public confidence is enhanced by the timely resolution of criminal offences by the authorities. The practice in Northern Ireland that the court can take into account whether the accused indicated his intention to plead guilty by admitting his involvement at interview is a practice that has been used by all of the jurisdictions in the United Kingdom at some time. The absence of a method of referring a case promptly to the Crown Court has informed the decision to continue to apply it in Northern Ireland. There is nothing unlawful about that course. Similarly, each jurisdiction has for long periods reduced the discount for a plea in cases where the accused was caught red-handed. The justification is that in cases where the evidence of guilt is overwhelming, the accused has in reality little option but to plead guilty. Of course, it is true that the utilitarian benefits are similar in the case of every early guilty plea, but that does not render the decision to apply the policy unlawful. The trial judge was entitled to reduce the discount for the plea for the reasons given by him, and the Court of Appeal was correct to uphold that decision. The appeal is dismissed.
The Court is adjourned.